Welcome everybody. And I'm so thrilled to have Justice Costom with us this evening. And anything about criminal law excites me because my dad was a criminal lawyer for 50 years. So I just know how super interesting this topic's going to be this evening. Susie's going to talk to us about her experience as a criminal judge and the changes that have been made in the system because of COVID. But before we get started, let me just tell you a little bit about Susie, or Justice Costom. She's married to Paul. She has 2 kids. Danielle is at Queen's and Andrew is in grade 11 at LCC. And I'm going to read because she has an incredible list of achievements and I can't memorize it all. So she graduated from law at McGill in 1993 and she has degrees in both civil and common law. Suzanne's worked as defense attorney. She's represented the Ontario Provincial Police. She was a sessional lecturer at McGill. She teaches at the National Justice Institute and at the Canadian Association of Provincial Court Judges. It's a bit of a mouthful because she's done so much. And she was appointed as a criminal judge in November 2016. So if you have any questions, please pop them in the chat and we will get to them when Susan's finished speaking. And I'm just going to throw it out to you right now. So take it away.
Thank you, Michaela. And thank you to all of you for inviting me to spend time with you tonight. This synagogue is really such an incredible place. We all feel connected to our religion in different ways, but for me, a big part of religion has always been community. And boy, has this community, under the leadership of Rabbi Shire, risen to the challenges of this surreal pandemic. In some ways, I feel more connected to the synagogue now, despite being physically absent, than I ever have before. I am in awe of how the Shire has brought people together through initiatives like Shire Cares and evenings such as this. So thank you to all of the professional and lay leadership for really being there for us when we need you the most. I've been asked to share with you what it's like to be a judge, and in particular to be a judge during these unprecedented times. And I'll start with talking about what it's like to be a judge during the pandemic because I can deal with that relatively quickly. In my court, criminal court, despite how it may sound in the news, cases are proceeding as always. People are entitled to have their trials within a reasonable time. Victims are entitled to see their alleged aggressors brought to justice within a reasonable delay. And so cases are proceeding as always, other than last March, April, and May, when we were only handling emergencies, and there were many, cases are proceeding. One change is that we use technology a lot more when possible. For example, at almost every stage of the proceeding, other than a trial, an accused who is detained, meaning they're not out on bail, they're behind bars while they're waiting for their trial, will appear in court by video conference rather than by being brought to court in person. And actually they like it because the days that they come to court, they're woken up at 5 in the morning and woken up and taken from their cells, and they spend the day in the holding cells in the courthouse, and they actually almost universally prefer appearing by video conference. Lawyers also have the ability now at certain stages to appear by video conference. And these are positive technological advances, which were somewhat in place before the pandemic, but their use has, of course, been accelerated over the past year. And I'm sure that we will continue to use these technological means when appropriate, even after all of this is over. So with that out of the way, let's talk about what it's like to be a judge more generally in criminal court. And as you may know, or anyone who knows me knows, I love it. And when I asked myself what I was going to share with you, I thought that I could break it down for you into the 2 reasons why I love being a judge in criminal court. So the first reason is that we are called upon to deal with, really on almost a daily basis, cases that relate to the fundamental freedoms which form the underpinnings of a free and democratic society. The second thing that I love is the human aspect of it. In almost every case, I am called upon to understand the strengths and weaknesses of human beings, to determine to what extent their particular situation has led them to appear before me, and when they commit crimes, to craft sentences which reflect the harm to society and the victim and the seriousness of their offense, but also which allows me to take into consideration the individual characteristics of the person in front of me. So I want to make all of this more concrete. So what I thought I would do actually for the rest of my sort of more formal part of my remarks is talk about two cases, which I think flesh out those ideas and illustrate to you what I'm trying to say. And then of course, as Michaela said, it would be my pleasure to answer any questions afterwards. So first, what do I mean when I talk about fundamental freedoms? I'm talking about things like the right to silence, the right to counsel, the right to privacy, the right not to be detained arbitrarily by the state. These are all things that come up regularly in criminal court. Last week, I actually released a judgment that dealt with a lot of these rights, sort of all in one. So I thought I would tell you a little bit about it, again, to sort of illustrate my point. So it all started at a residential apartment building not very far from the synagogue. There was a water leak in an apartment on the second floor, and so the concierge was tasked with identifying the source of the leak. Not surprisingly, he went and knocked on the door of the apartment on the third floor, the apartment directly above the apartment with the leak. There was no answer, so he let himself in with the master key. This was a small 3.5 apartment, and he immediately fell upon computer printers, monitors, and in one of the computer printers there was a half-finished Medicare card. In bags on the floor, there were sports bags which contained Medicare cards, mostly Medicare cards and licenses with the names and photos of multiple different people. And as an aside, I should mention that he did not find the source of the leak. In any event, he let himself out of the apartment quite shaken up because he understood that he had unwittingly fallen upon what in police jargon they call a laboratory for making fake identification cards. I should add that the concierge was new and he didn't know the tenant of that third floor apartment either by name or by face. So the concierge leaves the apartment, calls his boss, who tells him to call the police, which he did. He gave the police a statement explaining what he saw, at which point the police decided that they were going to do two things. First, they were going to get busy drafting what they needed to draft in order to go before a judge to request an authorization to get a search warrant to search and seize all of the materials which the concierge had seen in that apartment. Second, they were going to send undercover officers to monitor the comings and goings at that particular apartment on the third floor. So while one officer remained at the station drafting the request for the search warrant, 5 plainclothes or undercover officers went to the building. 2 of them were stationed on the third floor. One was by the elevator and the other was in the hall leading to the apartment. What you need to know is that this floor contained 20 apartments, and the apartment in question was up a small flight of stairs, at the top of which contained 2 apartments side by side. Not long after the undercover officers arrived, an individual exited the elevator on the third floor and walked down the hall in the direction of the apartment in question. Halfway down the hall, he turned around, sort of doubled back, headed back towards the elevator, but walked past the elevator to head down the stairs. One of the officers followed him down the stairs and told him to stop and that he was under arrest for fabrication of false identification cards. The individual was brought to the lobby. He was handcuffed. He was advised of his rights. The undercover officer called for backup from 2 uniformed officers who arrived about a half an hour later, did a pat-down search on the individual, and put him in the back of their cruiser, where he stayed for about a half an hour on this busy street. One officer stayed with him in the car, and the other went to search his car, the arrested person's car, which was parked just a few spots away. While he was in the car, the individual asked if he could speak to a lawyer, and the police officers told him that he could do so once they arrived at the police station. However, once they arrived at the station, these officers were advised by their superior, the one who was drafting the request for the search warrant, that the individual could not actually contact his lawyer immediately, as his right to counsel was suspended or postponed until the police were able to go into the apartment and execute the search. So the individual was placed in a cell to wait. About 6 hours later, the search warrant, now having been obtained, was in the midst of being executed. They entered the apartment, the police did, and seized all of the incriminating evidence, the computer equipment, and the counterfeit cards. Once the search was underway, the individual was indeed allowed to contact a lawyer. At his trial for the fabrication and possession of these fake cards, the individual argued that his arrest and detention were illegal and arbitrary, and that his right to counsel had been violated. The prosecutor argued that given what she characterized as the individual's weird behavior upon his arrival on the third floor and the presence of equipment in the apartment, there were reasonable and probable grounds to justify his arrest. She also argued that although as a general rule, an individual must be allowed to contact his or her lawyer immediately upon arrest, in this case, the suspension or postponement of the right to counsel was justified. In her opinion, there was no way of knowing if there was anyone else still in the apartment before the police arrived. So if the individual had been allowed to contact a lawyer, according to the prosecutor, there was a possibility that news could get to anyone who may be in the apartment, that the police were onto them, and valuable evidence could be destroyed. In the circumstances, it was therefore appropriate, in her view, to wait for the police to enter the apartment and secure the evidence before allowing the arrested individual to communicate with anyone, including a lawyer. So the first thing I had to determine was whether there were reasonable and probable grounds to arrest this individual. Now, here's where, if we weren't on Zoom, I would be stopping and hopefully interacting with all of you in order to get your feedback. And I'd be really, really curious to get your reaction to the sequence of events. So think for a second about what you think that you would do if you were me and had to make this decision. Okay, so in my opinion, and this is what I wrote in my judgment, there clearly were not reasonable and probable grounds to arrest this person for the fabrication of forged cards. My decision was amplified by the fact that in cross-examination, the arresting officer candidly admitted that he would have arrested anyone who he thought was heading towards the apartment in question. An 85-year-old woman, a 14-year-old child, or a middle-aged man like the one who was ultimately arrested. In my decision, I wrote that while it may have been legitimate to suspect that the accused was heading towards that apartment, the police had basically acted too quickly. In our legal system, an arrest cannot be done unless you have reasonable and probable grounds to believe that a particular person has committed a particular crime. The individual was handcuffed in the lobby of the apartment building and in the back of the patrol car in plain view of anyone who may have been in the area. In addition to his loss of freedom of movement, one can't underestimate the loss of dignity that one experiences in a situation like that. And that is exactly what the Canadian Charter of Rights and Freedoms protects. And that's why we are protected against illegal or arbitrary detention and arrest. When there are not reasonable and probable grounds to arrest someone, that detention is indeed arbitrary and violates the Charter. The second thing I had to answer was whether it was appropriate for the individual's right to counsel to be suspended, in other words, postponed for 6 hours before being allowed to call a lawyer. So again, I'd be curious to know what you think. What you need to know is that the right to counsel has been interpreted to mean the right to contact or consult counsel immediately or as soon as reasonably possible upon arrest or detention, barring exceptional circumstances. Where the contact is not immediate, it is up to the state or the prosecution to justify why. And there may be times when it is justifiable for officer safety reasons or for the preservation of evidence. However, in my opinion, this was not one of those cases. When I'm called upon to make decisions such as the ones I had to make in this case, what I really have to think about is why the right exists and the way that it is supposed to be applied to all of us, not just to the individual in front of me. So I think to myself, if the person walking down the hall had been our friend, our parents, our kids, and they told us about the situation, would we think it was appropriate for them to have been arrested, detained, handcuffed, placed in the back of a police car? That's really what I'm being called upon to decide when I'm asked to make decisions such as this. Furthermore, assuming, for argument's sake, that a person is arrested legitimately, based on reasonable and probable grounds, would we think it was okay for them to have no access to legal advice for 6 hours? Again, think of your friend or your child. Even if they were arrested on reasonable probable grounds, in the middle of doing something, graffiti on an apartment building, impaired or dangerous driving, or even more serious offenses, imagine the fear and the vulnerability of being in a holding cell for 6 hours with no access to advice, no idea of what was happening to you, or even how long you were going to be there. And that's what I mean when I talk about fundamental freedoms in a free and democratic society. I should add as a postscript that there's a difference between me finding that rights have been violated and me determining what the remedy or consequence of that violation should be. Just because I find that rights have been violated, this does not necessarily lead to an acquittal or a finding of not guilty for the individual whose rights were violated. In this case, because of the illegal arrest and the illegal delay in allowing him to exercise his right to counsel, the accused was asking me to exclude from evidence everything that had been found in the course of the investigation. The evidence that was found on him when he was given the pat-down search, the evidence found in his bag that he had with him, the evidence found in his car, as well as all of the material that was found and seized pursuant to the search warrant that was executed at the apartment. What I decided was that the evidence seized on him, in his bag, and in his car should be excluded from evidence. They were just too closely connected to the illegal arrest, and their use would bring the administration of justice into disrepute, which is the test we need to apply in order to determine whether or not to exclude or admit evidence. However, I did not exclude from evidence all of the evidence that was seized pursuant to the search. There was a legal search warrant that had been issued based on reasonable and probable grounds. The information that was used in order to justify the issuance of the search warrant existed independent of the arrests. It came almost exclusively from the concierge. Even if there had been no one arrested that night, they still would have been able to obtain a search warrant because there were reasonable grounds to believe that evidence of a particular crime was found in a particular place. So I determined that the evidence found in the apartment was legitimately found and could be used. So the trial will continue based on the evidence that was seized from the apartment. Stay tuned. Now, as I said earlier, the other thing that I really love about being a judge in criminal court is the human aspect of it. And that comes up most clearly in many sentencing decisions that I need to make. Very often, individuals plead guilty in front of me, and I'm called upon to craft the appropriate sentence. Or, of course, I impose sentences after a finding of guilt, after a contested trial. But there are a lot of guilty pleas. In Canadian criminal law, we do not have the same sort of sentencing guidelines as those that exist in the United States. I'm not an expert in American law, but my sense is that in many jurisdictions in the United States, there are very, very particular fixed ranges for particular crimes, and there is very, very little room for discretion. And in Canada, our approach is really different. The overwhelming majority of offenses are punishable by maximum sentences: 6 months, 2 years, 5 years, 10 years, 14 years, or life, but there's no minimum. The maximums are important because they help us determine the objective gravity or seriousness of the offense. Of course, the higher the maximum, the more serious the offense. And of course, there's also precedent, which gives us a general sense of what similar offenders in similar circumstances have received by way of sentencing in the past. However, fundamentally, sentencing is at the discretion of the sentencing judge, who must impose a sentence which is proportional to the gravity of the crime and the moral culpability of the offender. Again, let me give you an example. A woman came before me and pleaded guilty to defrauding her employer's insurance company of something like $100,000. This was a medium-sized business, and she had been working there for years. She was trusted implicitly by her employers, who viewed her almost as a member of the family. There was a generous health insurance plan, and it was determined that she had been submitting false claims for a period of 2 or 3 years, claiming that she or members of her family had received health services, which in fact she hadn't received, and being reimbursed for them nonetheless. She submitted claims using the names of 17 different healthcare professionals who all provided evidence that they had not provided any services. So following her guilty plea, I was called upon to sentence her. In recent years, fraud has been punished more and more severely. I think that in the past, there was some sense that economic crime or white-collar crime was not as serious or as bad as blue-collar crime. But we've become more and more focused in recent years on recognizing how terrible it is for the victims, often the vulnerable victims of economic crime, and the terrible toll that economic crime can take on people. We've also have a preoccupation rightfully so, of making sure that people understand that crime doesn't pay and that to commit crimes like this, people will be punished severely. The other thing I needed to sort of keep in mind in coming up with the appropriate sentence was that this was not just one isolated lapse or one isolated error in judgment. This crime took place over a period of a couple of years, and that certainly makes it worse. The fact that this woman was in a position of trust and abused it is also a significant aggravating factor. As a society, employers need to be able to trust their employees to whom they delegate significant power and control. And a failure to respect that position of trust must, according to the case law, be punished severely. It would not be unusual in a case like this with these sorts of aggravating features and a fraud of $100,000 to be punished by years. But the analysis doesn't end there because we sentence crimes, but we also sentence people. At the sentencing hearing, the defense came before me and pleaded that in the very particular circumstance of this case, despite the fact that admittedly jail would generally be the appropriate sentence for a crime of this nature, I should not send this particular person, this woman, to jail. The woman testified and expressed her regret and shame at having acted in a criminal manner. She took full responsibility for her actions. Numerous documents were also submitted in support of her testimony. From her testimony and the documents, I learned that after a very difficult and complicated pregnancy, this woman's second child was born with a congenital heart defect. He was rushed to the hospital upon birth and spent 17 days in intensive care. Over the next couple of months, he had multiple open heart surgeries. The mother already was juggling time between her full-time job, the hospital, and her older son, a 4-year-old, who was at home. She was suffering from post-traumatic stress syndrome based on the difficult pregnancy and the delivery, and her husband was in a total depression and was of absolutely no support to her. Sadly, this was only the beginning of this mother's problems. When the child was 18 months old, it became clear that he was not meeting developmental milestones. An evaluation was done, and it was confirmed that he was suffering from autism spectrum disorder. Documents submitted in court at the time of the sentencing hearing included recommendations that the child benefit from early specialized treatment in order to maximize his developmental potential. Time was of the essence. The earlier these treatments were administered, the better the chance of success. The reports that were submitted in evidence indicated that such services were technically available in the public sector, but were subject to long waits of a year or even 2. But yet they were readily available, although costly, in the private sector. Within that context, after other efforts, again, that were documented in front of me, to find money had failed, the mother committed the fraud in order to have access to funds to treat her child. I could go on, because the story actually gets worse, but suffice it to say that with all the evidence before me, it became clear that despite the fact that a fraud of this nature would normally merit a significant jail sentence, this mother, this person, did not need to go behind bars. I sentenced her to an 18-month house arrest to perform a significant number of hours of community service and subject her to a 3-year probation order. Now, many may think that house arrest is not a severe punishment, but those of us who have been subject to quarantine at any time over the past year, when one is not even allowed to step foot out of our homes, now realize how difficult it actually is. Now, if I take a step back from all of this, what I think is important is this. We all have the tendency, when we read the paper and hear about terrible crimes, to want to throw the book at the offender. When crimes are committed, we feel targeted. We feel like we could have been the victims. And the sentencing process certainly must take those legitimate fears and those legitimate feelings into account. In fact, the criminal law exists to uphold societal values and our determination of what is appropriate conduct. And of course, it also exists fundamentally to keep society safe. Yet behind every crime is a person with a life story and a baggage. So my task in a case like this, and in so many other difficult sentencing cases, is to find a sentence which sends a message to society and to the offender that the behavior is wrong and will not be tolerated, while at the same time recognizing that despite this woman's grave error, her criminal conduct, that she had the potential for rehabilitation. Just going to check our time. Okay, I'm going to tell one more quick sentencing anecdote because I have the time. And this has to do with a young man, just 18 years old, who never had a break in his life. An absent father, a mother struggling with addictions, and an older brother who was his idol, who not surprisingly himself succumbed to addictions and began committing crime in order to finance his habit. Shortly after his 18th birthday, this young man did the same thing. He became addicted to drugs. Well, he probably already was addicted to drugs, but he began committing all sorts of property crimes, stealing cars, stealing from stores in order to finance his drug habit. The young man pleaded guilty in front of me really early on in the proceedings to a whole bunch of property crimes. And his lawyer suggested that he would be willing to do a 6-month treatment in a closed facility, meaning that he would have to stay somewhere for 6 months, 24 hours a day, 7 days a week, in order to hopefully kick his drug habit. The case ended up going on for a long time as the young man followed various treatment options, messed up a few times, but ultimately got his life back on track. By the time I sentenced him, he was over 20 years old, had been drug-free for over a year, had a terrific girlfriend who I remember to this day, who testified in front of me and who was clearly a fantastic influence on him. He was working full-time and he was back in school. His lawyer told me that the fact that the court had been patient before sentencing him, and the fact that this kid knew that he was going to have to come before me and face me every few months with a status report, had been central to his ability to overcome the many obstacles which he had faced over time. And ultimately, due to his own perseverance and hard work, he earned a much less severe sentence than what he would otherwise have expected to receive had I sentenced an 18-year-old druggie with no direction. And this, of course, was better not only for him, but for society, as he was able to break the cycle of criminality. Of course, not all the stories I see are as sympathetic, and not all of them have happy endings. But I do believe that as a justice system, we do, in most cases, strike the appropriate balance between allowing law enforcement authorities to do their jobs, while at the same time ensuring that individual liberties are respected, and a system that imposes punitive punishments when necessary, but also leaves space for rehabilitation and second chances. I genuinely feel privileged to play a role in this system. I also feel privileged to have had the opportunity to speak with you tonight, and I'm going to stop here. Thank you, Michaela and the Sisterhood, for inviting me. And again, thank you to Rabbi Shire and all the professionals and volunteers for your incredible leadership during this time. And it would be my pleasure to answer any questions.
Thank you. That was amazing. Amazing. There are a couple of questions, but I just want to say that I think we've become so desensitized from television and media when it comes to crimes that it's actually interesting and nice to hear that you forget when you said sentence crimes, but you sentence people as well. We forget that people aspect behind it, which actually leads into this question someone had asked. It must be extremely difficult to rule against someone who has committed a crime and yet pulls at your heartstrings as an otherwise decent person who has made a horrible decision. How do you manage your feelings?
So it is a good question. And of course, I think that you can tell because I'm talking about my interest and sort of love, generally speaking, for humans, that is very hard for me. What I try to do, and I have to say, I think for the most part, although I don't get feedback from them, I think for the most part, I'm able to do this somewhat successfully, is that when I sentence someone, I often will address them, even if it's a sort of formal written judgment, and explain to the person why it is that they need to have the sentence that they're receiving. And so this may be hard to believe, but there have been times when I've imposed very serious sentences on people, and they've sort of looked at me at the end and almost said thank you, or even said thank you, because I think that when you explain things to people properly and they understand why, and they don't just feel that you're being punitive for the sake of being punitive, if they are, as your premise suggested, otherwise reasonably decent people, they actually sort of can accept it.
Okay, perfect. Thank you. There's another question. Have you ever had a fear of reprisal after sentencing a serious criminal?
So, my grandmother used to say to me, "Why are you going into criminal law? It's all these criminals, they're going to hurt you." And I understand the question, and I understand why people would have that sort of question and sort of concern. But my short answer is no, I really never have. Again, I think that for the most part, if you play by the rules and you do things properly and you make people feel that they've been heard, that you've listened to them, and that you are applying the rules and playing the game fairly, um, that you're safe. Look, there's always crazies in the world, and that's in any field. But sort of generally speaking, I don't walk around in fear at all, at all, at all.
That's good. We used to get weird phone calls from people that only had one call.
For your father, yeah.
My father, exactly. If you had to judge a criminal for anti-Semitic vandalism, would you recuse yourself?
Yeah, that's a good question. I think that what I would probably do would be have a chat with my coordinating justice. There is a coordinating judge that assigns cases. We are 40 judges in Montreal who sit in criminal court on the court that I sit, or a little less than 40. Two of us are Jewish, myself and Lori Weitzman, who I'm sure a lot of people in the audience knows. I don't know that we would necessarily be the first people that they would think of to assign the case to us. Technically speaking, there would be no reason why I couldn't hear it, because I think that I could be independent. Practically speaking, I think the case probably just be assigned to somebody else.
Okay. Makes sense. It would make sense. How much do you take a victim impact statement into account when sentencing?
Very, very, very much. Different victims react to different crimes in different ways. It's really, really helpful for us to get victim impact statements when a person is a victim of a crime. If the system is working the way it's supposed to, they're supposed to be given the opportunity to complete a victim impact statement. They're supposed to be given the opportunity even to come before the judge and testify, or read a letter, or say a poem, or say a song, anything that can express the magnitude of the suffering that the offense caused. And it's really, 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 really helpful for us. And it may mean that the same behavior will affect victims in different ways, and therefore may lead to a more serious sentence if the victim was more effective. That's again part of the human nature of the system. We don't only look at the particularities of the offender; we look at the particularities of the victim. Those are all things that become a part of the sort of art of crafting a sentence.
Have you ever visited prisons in Quebec?
So as a judge, I never visit prisons, but as a defense lawyer, I visited prisons. But many years ago, I didn't have that type of clientele that sort of required me to go to prisons all that often. But I definitely visited prisons as a defense lawyer.
Okay, so now I'm going to ask you the most difficult case that you've had, and any funny. My dad used to tell us some really funny things, but there must be something entertaining that's happened in court or something.
Well, there have been a bunch of funny things. Some of them I can't repeat because they're sort of X-rated. But I don't know how funny this is going to sound, but there was a case that was being heard. It was a simple assault case. It wasn't a sort of major case where anyone got particularly hurt, but it was a big case for the people involved. And it just so happens that on that day, I had two fabulous girlfriends that came. They wanted to see me in court. So they came and sat in the courtroom while they listened to this case. And they were to this day, they still talk about the fact that the big assault was that the guy had thrown a bagel onto the woman, and he was charged with assault with a weapon, the weapon being a bagel. So that was, not my most glamorous case, but for the people that came to the courtroom, it was hysterical. People, that's not what people think when they think about criminal court, clearly. So that was one case that was very funny. In terms of difficult cases, I have to say, I think that the sentencing cases are most difficult for me. That case with the woman that I was talking about during my remarks was exceptionally sad. There was an article in the newspaper a few years ago that said, is it okay for judges to cry on the bench? And there's this sort of debate. And there are cases sometimes that bring me to tears, either from the perspective of a victim or the perspective of the accused. I had a terrible case a couple of years ago, a dangerous driving case, where the accused was coming home from downtown with a bunch of friends in his car, also a young man. and he lost control of the car. He was speeding, he hit a median, and the passenger, a young woman, died on impact. And it was about a 5-day sentencing hearing because the woman's family, everyone wanted to testify. The mother, the father, the brother, the friends. I mean, they all were victims and lost this young, precious woman far too young, and they all wanted to testify in front of me. And it felt by the end of it like I had suffered a personal loss, because I felt like I knew her from how they explained her to me, which was actually really effective. But it felt like I was in a funeral for 5 days. It was really, really, really hard to hold back tears in a case like that. And for the offender, his family also was destroyed. His family certainly hadn't done anything wrong, and they came and sort of pleaded for mercy. It was an exceptionally difficult case for me.
Yeah, and it must be hard to de-stress from something like that.
Well, that's why you take your decision under reserve. In criminal law, unlike in civil law, we actually will set a date. It's not just, okay, bye, you'll get your judgment when you get your judgment. We actually will say, okay, I'm going to render my judgment in 6 weeks, in 8 weeks, whatever the date is, 3 weeks, 2 weeks. I try and do them relatively quickly. And I have to say, taking a step back and taking the time to think about it, to review things without that emotion, is really, really helpful.
Okay. How do you feel about the law that forbids judges to wear religious symbols?
Yeah, so I can't answer that question. Yeah.
Okay. How do you deal with when he says, she says? Who do you believe?
Well, I'm going to give an answer which is probably going to be unsatisfactory to anyone who asked that question, but every case is decided on its own merits. So I don't look at any particular case as a he says, she says. I look at every case and I say, has evidence been made of the essential elements of the crime beyond a reasonable doubt? And if that's the case, then I will convict. And if I have a reasonable doubt for any reason, then I will acquit.
Okay. Why could two criminals commit the same crime in the same way and yet be punished differently depending on the personality of the victim or the victim impact statement?
So that's a really good question. And I have to say it is something that that may be a little bit hard to understand, but I guess, you take your victims as you find them. So if I happen to, if I'm an offender and I happen to hit someone who has, who falls back and hits their head on the ground and dies, well, I might be charged with manslaughter. If I hit someone and they just take a few steps back and they, just sort of walk away and say, why'd you just do that? Well, then I'm charged maybe with assault. And in fact, I've committed the same behavior, but one has led to a death and one has led to sort of an innocuous incident. And the same thing applies in sentencing. We have to take into account the consequences of a crime. And so the fact that consequences are different in different circumstances is one of the elements that we're going to take into consideration in sentencing people.
Is part of your job interpretation, not just the law, but because if there were two judges, would they come with the same, there would be different, would they have different outcomes, different views? Is it interpreting the law or interpreting the situation according to you? Do you know what I'm saying?
No, I mean, look, we are duty bound to apply the law. So where a law is clear and there's no ambiguity, then it is our responsibility not to have an opinion on whether we agree or disagree with the law, but apply the law as the legislator intends for us to apply it. Where there is ambiguity, look, we're humans, right? So two reasonable people, two hardworking people, two honest people, in the case of ambiguity, as is the case in any situation in life, not only in applying the law, may come up with different interpretations. And that's why appeal courts exist, because if there's ambiguity or different interpretations and that needs to be cleared up, well, then eventually there's going to be an appellate court that's going to tell us sort of how the law is intended to be interpreted.
Okay. When did you know that law was your future?
When I went to law school, I knew that I wanted to study the law. I wasn't 100% sure that I wanted to be a lawyer. I knew that it would be interesting and that it would provide a fabulous foundation for whatever I wanted to do. I thought maybe I wanted to be a journalist. I, at some point, had these visions of being a foreign correspondent. This is Suzanne Costom reporting from Moscow. Or, I realized very, very early on, though, that I did want to practice law. And I chose criminal law in addition to the reasons that I mentioned already, because I wanted to be a litigator, and criminal law is very, very court driven. And I knew I wanted to do public law. I wanted to deal with sort of public law issues. I didn't want to be dealing with sort of the business side of things.
Yeah, and it's very interesting. I think it's super interesting. Do most of your colleagues have similar empathy and considerations as you do towards the criminals?
I think that they do. I mean, I obviously can't speak for everybody. I think that people that go into criminal law have to have a lot of patience for humans and all of their warts and all of their life stories. We hear so much of it that if you don't, if you're not interested in that, if you don't empathize with that, it would make the job very, very difficult. So most of us have backgrounds in criminal law, either as prosecutors or as defense lawyers. And for the most part, we are all interested in sort of the human condition. So yes, I mean, look, different people are going to react differently to different things. Our system is human. Yeah. There's no question. But I think that most of my colleagues have a very open ear and are empathetic.
How many female judges are there in Montreal?
So I don't know specifically in my, the 40 that I mentioned before, but like overall in the Cour de Quebec, we're half or maybe even a little bit more than half female.
Oh, great.
So it's fantastic. Yeah.
Really then? Okay. What percentage of your cases have been found not guilty?
Oh, I have no idea. I would never know such a statistic. I because my cases, first of all, they would never give us statistics like that because they're basically irrelevant. Each case is going to be decided based on its own facts, and it's luck of the draw which kind of cases you end up with. But there also are a lot of cases which end up with guilty pleas. And that could be like the case that I talked about before, the dangerous driving with the woman and her family. I mean, that was a 5-day hearing. That was an intense hearing, but it was a sentencing hearing. It was a guilty plea and then sentencing. Mm-hmm. So there's a lot more than just deciding whether or not we find someone guilty or acquit people. So I have no idea.
Okay. I'm not sure about this question, if you can answer it. What do you think of the new travel hotel quarantine? Is that unlawful detainment?
I can't answer that. I'm sorry. Yeah.
Have any of your cases gone to appeal, and how did you react to the outcome?
So it's funny, because people ask, trial court judges about that all the time. How do you feel if it goes to appeal? And I have to say that it actually makes me sleep better at night to know that there's an appeal court, because if I get it wrong, I'm happy for there to be someone to tell me that I got it wrong. Of course, I don't want to get it wrong. I do my very, very best to get it right. But I don't, appeal courts don't scare me. I actually only have one case that was taken to appeal. It was very recent that we got the decision, and I was upheld. And it's for sure it felt good. Because I had worked hard on the case, and I was happy to hear that the appeal court agreed with my interpretation and my application of the law. But I would have been fine if they'd overturned me too.
How does one become a judge? Are you invited, or do you have to apply?
So you have to apply. You have to be a lawyer for at least 10 years, a lawyer in good standing, and then you have to apply, and there's an interview process. And it goes from there.
How many judges do they choose? How often do they choose a new judge?
So the way it works is that the Judges Act has a certain number of positions. And so right now, I might be saying the number wrong for Montreal Criminal Court. Let's say it's 40, let's say it's 38, it's something in that range. So the only way that a new position would become available is if someone passed away or retired, because they are not adding judges unless there's an amendment to the law, which would change the law and create more positions. Okay. So someone has to pass away or retire. There's a concours or an avis de sélection, and then there'll be the interview process.
I find the concept of concurrent sentences hard to understand as opposed to consecutive sentences. It's possible to spend the same time in prison if you kill one person or 6 people?
Right. So just to sort of make sure that everybody in the crowd understands, concurrent sentences means that if I impose 2 sentences on someone, let's say 2 life sentences, It's not life followed by life, as you sometimes hear in the States. They talk about consecutive life sentences, or let's take an easier number, 10 years, 2 10-year sentences on people. It's not always 10 plus 10. It could be, in which case that would be a consecutive sentence, but it also could be a concurrent sentence. And that stems from the principle, what we call the totality of the sentence. The principle that although you need to sentence each crime, you need to look at the total sentence and make sure that it's not disproportionate or unduly harsh. And so sometimes it's true that even when more than one crime is committed, a person will serve one 10-year sentence, sort of, well, 2 10-year sentences, but feels like one 10-year sentence because they're being served at the same time, rather than 2 consecutive sentences. And there's criteria in the case law and in the criminal code as to when we will impose consecutive and when we will impose concurrent. But as I say, it stems, amongst other things, from the principle that we don't want to sort of have a total sentence which is too harsh, because we do believe that one day the person is going to come out and is going to hopefully be rehabilitated and integrate into society. We don't believe in throw them in jail and walk away, and throw them in jail and throw away the key.
Okay. Any instances where a guilty judgment was given, but the person was later found innocent?
Well, I hope not. I mean, not to my knowledge in my cases. And I listen, there's the famous ones. There's the Marshall and the Milgard and cases that we hear about all the time. And those are sort of the biggest miscarriages of justice and to be avoided at all costs. In the particular circumstances of my courthouse and my colleagues, I'm certainly not aware of it. I guess the way that they could be found innocent is if a case was, brought to appeal, and either the acquittal was done by the appeal court, which would be very, very, very rare, or sent back to trial and a person was found not guilty. What I guess I should underscore is that when a person is found not guilty, it doesn't necessarily mean that they're factually innocent. Again, it just may mean that their evidence was obtained illegally and therefore there's no evidence against them. It could mean that the proof just didn't hit that threshold of beyond reasonable doubt. So factual innocence is a relatively hard thing to prove in criminal law.
Yeah, because it must be hard. I don't know if you know that they're guilty, but you actually can't do anything about it because it was done illegally, whatever, wasn't.
Yeah, it's how should I say? As a human being, if you quote unquote know that someone did something, it's not necessarily fun if you need to end the case against them. However, as a jurist that believes in the system and believes in the sort of fundamental precepts of the system, you can live with it because there are bigger issues at stake than just that one case.
Mm-hmm. Okay, well, that's all our questions. Does anyone else have another question? Let me just double check. There's no more questions. So fascinating. I could just talk about this forever. Is criminal law a federal or provincial jurisdiction?
So the criminal code is a federal piece of legislation. There are certain provincial offenses that we sometimes deal with. So there could be a case, for example, a tax prosecution. There could be provincial tax prosecutions. There could be federal tax prosecutions under the Federal Tax Act. But generally speaking, criminal law in terms of criminal code, true crime, is federal, which means that the law is the same across the country.
Okay. Any last quick story you want to share with us or something?
I don't, but it was fun, and I
Thank you. We so appreciate it. There were 185 people that came to listen to you.
Oh boy, yeah,
really interesting. So thank you so much. Super interesting.
Well, congratulations to you, to Michaela, to the sisterhood and as I say at the beginning, I really am amazed by how the synagogue has brought people together during this time. So again, congratulations to everybody who's involved in the synagogue in any way.
Thank you. And I'm just going to remind everyone that our next sisterhood event is March the 8th, and it's with Selena and Oro, and it's a storytelling. And I'm really looking forward to that. I've never heard them before. It's called Doing the Right Thing, Wisdom Tales of the Jewish Traditions. So March the 8th at 7:30. So thank you again, Susie.
Thanks, Michaela.